So we start the work, dear colleagues. First, I would like to mention the need of this section has been that in order to protect social rights, including by the administrative court, we need to understand what are the social rights, what are their indicators, what is their content. Within our first section, we will be talking about issues to characterize the social rights and state legal mechanism of their protection. I would like to speak about the organizational aspects to keep to the time schedule. So about the duration of the presentation and so on. So let me give the floor with pleasure to Doctor of Law, Professor of the Academician of the National Academy of Legal Sciences. That's from the Department of Theory and State and Law, Koretsky Institute of the State of Ukraine, member of the Scientific and Advisory Board of the Supreme Natalia Onishchenko. You're welcome, Natalia. Thank you. I would like to welcome all participants to wish all constructive work here, to welcome and to thank the organizers for this organizing of this event. I would like to thank also Mrs. Valentina Danishevska for this opportunity to speak at this respective. Social rights is rather interesting page in our doctrine. They are discussed by the academia, by the practitioners. I would like to be focused not on the just definitive textbook presentation of the development of social science, but rather on certain segments of especially just very important issues which are discussed and which raise our attention. It's our content of the social rights. It should include also some provisions of the International Pact on Economic, Social, Cultural Rights, which just give this opportunity to develop gradually such rights in view of the financial situation and financial capacity. This issue of the constitutional complaint, particularly constitutional complaint, because the question is about social rights. It's the ability of the judicial system in protecting the human rights. And there are also issues which are also of interest to theoretician and practice. So what is the content of the social rights? It is defined differently. It's the social relations integrated into the practice. That is the civil rights that to provide for the social good. I like very much the definition by the expert, or Mr. Deltave, who defined the social rights as the protection of the safety of the person in the presidency. I would like to also to say that social rights connect with the efficiency of the economic system, of the legislation, but a very interesting issue for us, what we put into the notion of social efficiency. What are these criteria about? What are these indexes? Attention should be given for us because we were not talking about it very much. Some indicators, some sites, some manifestations, symptoms of certain risk can be used to determine the level and quality of a process itself. These are the criteria are directly related to the needs, interests, goals of social development, both national and regional. And on the other hand, we provide an opportunity to see and to measure the satisfaction of implementation, realization of urgent needs, interests, and goals of each member of society. Of course, we understand that rights that's ensured, enforced within the system that adequately does reflect. We should state, also our state turned out regretfully not just not approximate to the European best practice to some threats, but also in fact the national legal system has demonstrated uh, that our legal system has demonstrated an arithmetic nature of functioning in such extreme circumstances. Although the national legal system is a kind of indicator of sustainable, approximate to economic, legal, political, and social development of each state. Therefore, the legal system should be capable of implementing some tasks and the implementation of some functions. A lot has been written that the social orientation of the legal system gains more strength, including it is manifested in the optimal combination of the legal and social principles, which are which are responsible for the social good. We should consider social good as social rights. That is the relevance between that's incomes of the able bodies. These are subsidies, relevant benefits, and it's quite a sufficient standard of living, a very interesting category. We know that this category is much discussed. And also in this about the regular course of events, as well as in the extreme course of events. A very interesting question, the implementation of social programs that would reflect these trends. Everything necessary has been taken into account. What should mean that? Also, it is critical to know what segment of social rights we are to safeguard. What is guaranteed by the state and defended by the judiciary? In what ways? What are these social rights that will be developed for decades, according, to a leftover principle? Or whether these are the social rights that will really help to live not only in a subsistent present-day Ukrainian realities, but rather have sufficient conditions for self-realization of the individual as well as for protection of his honor and dignity. That is a sufficient standard of living. The right to an adequate standard, which has not been well regulated in the national law, which has not been well regulated by the international documents. We understand the difference. But nevertheless, we understand that the provision for the sufficient standard of living is that standard of living that should be guaranteed by the state, not to be lowered. It relates to the internal resource of the state, but at the same, that's the concept of sufficient standard of living for sufficient just food. I'd say that probably does it to say that's a right to for better living. We use that. That's the right for a better. Dear colleagues, when we will be talking about pushing the questions about the right to a better living, that's the issue, the core of the issue, and that's the issue of the. Undoubtedly, I would like also to say about the right to healthcare. Article 35 of the Charter of the Fundamental Rights of the European Union, and article of the same charter is very important, and that's the practical conclusion, which I would like to mention here. The right to the integrity of the personality, about the effects of the immunization or effects of the vaccines. We are waiting for vaccines. So now the state should pay particular to this right to be informed, for this right of each person to be informed about the effects of different vaccination. So there are no persons that would not be worried about that now, and that these conditions, when that they should speak about the correspondence of the social practice to social duties, about the adequacy of the responsibility of the state and the big corporations and each member of the society. Dear colleagues, the well-thought social policy, properly developed social policy, just think about that, so the correspondence of the multifaceted development and just founding principles of our development. Therefore, I wish successes and both to set theoretician practices and to does your honest judges in this very complex matter. Thank you for your attention. Thanks a lot, Natalia Nikolevna. In continuation of the presentation, I would like to focus on finish about the just a reasonable proposal about the right to a better living. And it is correlated with the provision which is in the US Constitution, the right to the aspiration to happiness. I think that's the direction it probably them. It's my great pleasure to give the floor to the judge at the administrative court of the city of Vienna, the head of the Mrs. Edith Seller. Mrs. Edith Seller is our traditional partner in conducting scientific and other events. And in this part, it will be interesting to hear from Mrs. Deet in what way we need to perceive social rights or from the point of view of Austrian administrative justice and just how to protect social rights. Mrs. Edith, you have the floor.
Good morning to everyone and a warm welcome also to my dear colleagues who are listening, and many thanks to the organizers that I can also contribute to this conference with some remarks from a European level and non-national level. Another Austrian colleague of mine will contribute from the purely Austrian perspective later on as well. I have prepared some slides and I hope we can share them. We have prepared together with the colleagues from Bravo Justice, and I'm happy if it's possible technically spoken to share now, otherwise later. I will always indicate when we have the next slide. Many thanks. Some remarks generally on the concept of justiciability in a very general point of view, but I think it's important because to understand why we debate on justiciability about social rights today. The reason is it has been a long debate. The reason is a historic schism, so to say, in the human rights understanding. We have negative liberties and we have positive liberties. For concerning the negative liberties, it's a civil and political right. The state must not interfere. So this was easier to become justiciable. Whereas with positive liberties, the state should do something. And this has been a historic schism in the international fora and debates going on. Social rights include everywhere a big range of rights, what has been mentioned today as well, like the right of standard of living itself includes many different patterns of social rights, starting with the right to food, right to water, right against forced evictions, or to have rights that states provide, for instance, programs against homelessness. So this is all standard of living. We have also health issues, including also social security issues, educational issues, work-related issues, with also the right to form trade unions, and we have also cultural activities. This is what I want to say is that it's very broad. The patterns are not uniform and cannot be seen unified in a unified way, but they depend on the sociological circumstances and also on territorial, on regional circumstances. This makes it also a bit difficult. The next slide, please, if possible. The international, some remarks on international instruments, which apply to all of us, all judges in Europe. They are very important for us. The most relevant international instruments on the UN level is the International Covenant on Social, Cultural, and Economic Rights. However, here you see the difference. It's interesting to see the difference of the wording already in between this International Covenant on Social, Economic, Cultural Rights and the sister, so to say, the International Covenant on Civil and Political Rights. In the latter one, so the Covenant on Civil and Political Rights, you have always had an individual complaint mechanism. So there was always a kind of justiciability on the international forum, whereas it was not for the International Covenant on Social, Economic, Cultural Rights. As well, the wording of the covenants are different. The civil and political covenant, right, they contain obligations, whereas in the covenant on economic, social, cultural rights, it's written on, you know, values, on kind of not obligations, but promotions and goals. So this is also a reason why it was complicated to make it justiciable. The UN treaty monitoring body for this covenant is the UN Committee on Economic, Social, Cultural Rights. This has done a good work in all these lots of years. So by and by, justiciability arose via three different approaches, contexts. The UN committee has always examined state reports, member states, they had to give a country report. They have also made general comments, which are available also in the internet. There are like general comments on obligations of states, like general comment number 3. So by and by, and it has always promoted that you need to have a complaint mechanism. Finally, since 2013, it has come into force an optional protocol for this covenant, which enables for those countries which have agreed to make it justiciable after exhaustion of local remedies. There's a certain complaint mechanism now, which is good. Other UN treaty monitoring bodies are a UN Committee on Racial Discrimination, against racial discrimination, and elimination of discrimination against women, as well as concerning the rights of the child. What has been mentioned today already several times is the European Charter, the European Social Charter, which is very important. Also, the European Court in Strasbourg gives citations and refers to the Social Charter. The committee on the European Committee, the monitoring body, has also done a good work. For instance, also in the financial crisis, in the Europe's financial crisis, it has given a decision when we had collective complaints against Greece, saying that the austerity measures taken by Greece have exacerbated the already severe human consequences of the economic crisis. So this is good. In general, on the international level, on the instruments, what has been mentioned today is of big concern for sure. The IDPs, the internally displaced persons. On the international level, I myself remember that it has only started since the mid-90s to raise awareness on this issue, namely when many national conflicts arose, for instance, on the Balkans. So the UN has become aware of it. There was a special rapporteur on IDPs. However, a big issue is for sure everywhere on IDPs is the state sovereignty. Therefore, it's not so easy for international instruments. However, even more important it is to give protection via social rights, because we have the international instruments for social rights. The ILO, I want to mention only, it's mainly the International Labour Organization with a declaration, and there is also a kind of mechanism, which complaint mechanism, work-related rights. And I come back to it in a minute. It's the European Convention on Human Rights, we all know. Yes, but this is an instrument of really special importance. So the next slide, thank you, is some practical remarks from point of view of a judge on justiciability, which are relevant everywhere, I say, irrespective of the specific national context. First, I want to say that justiciability of every international covenant instrument depends on the specific national system, how to implement international obligations, international treaties. This differs from state to state. Therefore, I think, for instance, also Austria has a different approach than Ukraine insofar. This is relevant for the UN instruments for the European Social Charter. Because on one hand side, we have the monist legal systems, which incorporate it immediately and which are immediately applicable also for the judge. and must be applied immediately as the instruments are. On the other side, we have dualist countries, dualist systems, where it's not automatically implemented, but it must be incorporated. However, again, I want to stress that for us Europeans, it is the European Convention on Human Rights, which has a specific standing in each of our countries, and which is a common bracket insofar, irrespective of whether we have a monist system or a dualist system, and therefore the convention is of specific importance for all of us. Second, I want to stress that social rights, it's important to make them justiciable, and the more social values are the more social values include human rights dimensions, dimensions, the more they become justiciable, sure. And it's justiciability is relevant not only for a wrong decision of the state, but also in case of inaction of the state. It is very important to have a legal aid system for social rights, absolutely important in order to give access to justice, and to make sure that you have equality of arms. Mainly, the other party to the case is always a state, in most cases, for social rights. Therefore, it's even more important for when somebody asks for social rights, to have equality of arms in the proceedings, in the judicial proceedings. We all need to have provisional measures or suspensive effects. So this is also an important procedural instrument relevant in order to enforce and to make social rights justiciable. And what has also been stressed by Anna today already is the independence of courts. Independence of courts and judges is truly the basic fundament for justiciability. Interestingly, I want to say that also European standards include social rights of judges in order to make sure that independence is guaranteed, independence of justice of the justice system as such, like instance that the remuneration must be of an adequate level also for pensions, and also that judges must be allowed to participate in judicial associations. So there are also some social rights. Third, I want to say content-wise that hardly any human right is absolute. So limitations exist also concerning social rights. Limitations which are proportionality, adequacy, or reasonableness. This makes it a bit complicated always, because it becomes very difficult to adjudicate what is the highest attainable standard of health, what is the adequate housing. So, but this is per se an unavoidable issue. And often in this area of rights, the legislator also grants and needs to grant, or it's reasonable to do so, to grant administrative discretion. And as we know, the legal control of discretion is usually not in such a depth of control like in other issues. And fourth, I want to stress that apart from every international instrument, we also have in, I think, each of our constitutions of all our welfare democratic states, constitutional values, provisions, and jurisprudence to guarantee a certain minimum conditions of a dignified life. Fifth, I want to say some practical challenges in a daily work for social rights as a judge it's always a specific issue that judges have on get the necessary expertise. For social rights, it's very important and very complicated. The professional capacity and expertise. Either there are different systems, either you have a system of experts, or in some countries we have some expert lay judges sitting in the bench in addition to the professional judge, or we have also in some countries some expert judges as such, or we have some specialized courts. The other issue that every court needs to have enough resources in order to make available a fair trial within a reasonable time. And I want to stress the reasonable time also concerning social rights is of a very big importance. And thirdly, what has been also mentioned today already several times, it's very important, and the problem everywhere is that the decisions must be enforceable as a decision as such, and they must be enforced. This is always also a big relevant issue. So, and I want to stress only give some mention, because time is short and I think I'm running out of time, to the jurisprudence of the European Court of Human Rights. The next slide, thank you very much. Which is, you all know, I'm very sure about it and know it in detail. The convention does not contain socio-economic rights as such on a broad basis. They are linked. Social security, social assistance is mainly linked to the right to property, Article 1, First Additional Protocol. Trade union rights, work-related rights are linked to the right to Article 11, right to form trade unions, assembly, and also Article 4, forced labor. And the other pattern is Article 8, private right of private life, contains many issues of mental or physical health. And together, all with it, usually it's an issue of discrimination involved in many cases. So starting with the ARI case, we have some cases provided. I have done only just randomly picked out some cases from different areas, like Van Kuck versus Germany with health insurance coverage for medical treatment when you want to change the gender identity. This is was Article 8 in combination with Article 14 of the Convention, a violation recognized by the court in Strasbourg. Stack and others versus United Kingdom. This concerns reduced earning allowances and retirement allowances, which was a discrimination from right to property. Budina versus Russia was only, so to say, an admissibility decision. The complaint was inadmissible in the year 2009 by the court in Strasbourg, but it was interesting because of this issue that the lady has complained that her pension allowances were below the established subsistence level. And the court has said, well, yes, it can be a problem with Article 3 of the convention, but in that case, she has not proven the relevance, and she has not proven that it was a problem with human dignity. Another case, Dodov versus Bulgaria, for instance, this concerned the disappearance of an Alzheimer patient from a nursing home. This was, and the lady or the man died afterwards. This was a violation of Article 2 of the convention. And concerning living conditions, Moldovan and others versus Romania, where it was a violation of Article 3 because of the housing conditions of group of evicted Roma persons. So to summarize that in all of our democratic welfare states, we have certain standards of living and to have sufficient degree of provision of a dignified life. When we have a democratic welfare state, we have separation of powers, and even the more it is very important the social rights are properly justiciable. It is also what has also been mentioned today already. I fully agree that it's very interesting. I think very interesting legal questions are and will be coming up in the ongoing pandemic of COVID-19, because here we have the right to health, and what is the proportionality also with respect to other fundamental rights. This is following the debates in the diverse countries. It pops up everywhere. And it's very complicated, but interesting questions. And I think we judges, we will be occupied with such questions also in the future. The next and the last slide. Thank you very much. This is only some further reading, some interesting articles I have found. I want to thank you very much. And I'm looking forward to discussion, if possible, online, or to deepen our exchange in person later. Stay healthy, and looking forward to seeing you all. Many thanks.
Thank you very much, Edith. We also wish you to stay
Edith, that we will be
safe
able
and
to
healthy
discuss further.
for us to
Before
be
we
able
give the
to meet
floor to
in
the
person.
next speaker,
Before I give the floor
Mr.
to the
Michaelis,
next
Doctor Law Professor, who is the position of the Director of the Comparative Law at the Uzhgorod University. I would like briefly to speak that in our colleagues participant in this, there was an opportunity to put forward their questions in written. During this conference, we will have also an opportunity to put questions by using the chat room, which are available at the bottom of which, and with an opportunity, will be given the floor to our reporters, speakers, in case these questions relate to them. And then we'll be able to, as Mr. Masavchin represents the constitutional, but we are dealing with the administrative. We have this opportunity to ask Mr. Mikhailov to be yes.
Good morning, dear colleagues. I would like to thank the Supreme Court for this opportunity to participate in this conference on the most important issue. In a conference in Wiesbaden, Germany, as part of the Ukrainian-German Free Association of Legal Professionals. I'll be speaking to the point, and I will give you I'll share the screen for you to see my presentation on this topic, and I will be speaking about legal reasoning in administrative court judgments and construing social rights. So then I will wait for your questions. Here we go. We will be discussing how certain court judgments are being reasoned when it comes to social rights. And I would like to underscore that we should see whether the right to education, for example, should be construed as a social right. So, in order to look at how judges reason their decisions, we often see this dilemma between the originalists, and that is the use of travaux préparatoires, and the proponents of the living law doctrine. It's a perpetuated problem which has no final solution within the adoption of court decisions when we say train our peers or our students. And I always emphasize that the Constitution of Ukraine as an open text is the only attempt to define in Article 140 on local self-government, where they try to list all of the settlements in Ukraine and failed. So, as well as in Article 6, whereby the power is separated into 3 branches. So we have to ascertain the will of the legislator. And since it comes to human rights are open and they are inalienable. And all the norms of law, if they run counter the human rights, will be null and void. And the state can, of course, limit the exercise of certain rights, but it should be envisioned in the law. It should be necessary in the democratic society and proportional. So understandably that the text of the constitution or the law cannot serve as the final argument in taking certain court decisions. And if we want to ascertain the will of the lawmaker, we won't be thinking of what they thought about the freedom of expression, for example, as in the American Constitution, for example. So we will be referring to the tool of travaux préparatoires. That is how a certain formula should be implemented. And these formula are open in nature, and the art of jurisprudence is to interpret texts. Since we are talking about human rights, colleagues, in particular such difficult rights as social rights that are not even mentioned directly in the Ukrainian constitution. But social rights in Germany, for example, are protected by the constitution. And there are several attempts even to apply AI in administering of justice. So we can agree that some foundations of AI are based on certain algorithms, and there are certain textual explanations, but when it comes to the balance of how to measure the sanctions, then the AI won't apply well. So according to certain criteria, certain AI algorithm can actually correct that mistake or error. So we should combine contextual and formal aspects related to the text. Text from the point of view of legal certainty is just a benchmark, and there are certain red flags or red lines that show you how the decision will be reasoned. Now, speaking about specific approaches to legal reasoning, so there's a huge school of thought in the theory of law, and here you can see different trends and methods. Here we speak about combination of reasoning techniques that are dependent or independent on laws. And the nature of the judicial activity is such that it is related directly to a specific case with the factual circumstances, with the circumstances of application of certain principles of law or certain legal constructions that we call norms. And when it comes to the norm of law, it's not only about the provisions of the statute, but it's also about the interpretation of the statute by the law. As the previous speaker said, that the courts are actually limited with amicus curiae, and they should respect the opinion of experts, because within the communicative democracy frameworks, courts should take those circumstances into account and make a well-weighed decision. So, and you can see that there are a lot of different approaches. You can see them on your screen. And you know most of them from the legal theory. So these approaches are applied differently, and they can combine in certain specific cases. Now, the doctrines of interpretation. Can you please wind up? Could you please be winding up? Your time is almost up. Okay. So when it comes to the definition of the elements of the approaches, we speak about main interpretation doctrines, and they are defined by established case law. For example, when it comes to human rights, you can see several concepts. For example, the concept of interpretation, or neutral foundations of interpretation. When the circumstances of the case dictate how you interpret the law. Now, speaking about social rights and specifics of Ukrainian courts, our court should be guided by the European Social Charter, first of all. And if we look at this charter, we will see that it first formulates certain social rights, very specific social rights in block 1, then positive obligations with regard to those rights, and the third block is about potential limitations to those rights allowable in a democratic society. Now, looking at the Constitution of Ukraine, the major arguments for the legal reasoning are that these rights are based on Article 3 of the Constitution, and it is honor and dignity of a person that are the highest social values of the state. And in other articles, you will find other rights. The major thing is about the second part of Article 3. Human rights and freedoms and their guarantees determine the essence and orientation to the activity of the state, and the state is answerable to the individual for its activity. The second component, I'm sorry, could you be winding up? Because we are lagging behind the schedule. Okay, now speaking about the social protection, in Article 46, there is the horizontal structure with 5 elements protected by the Constitution. That's the social protection in the cases of partial or temporary disability, loss of principal wage earner, employment due to circumstances beyond the control of the person's control, old age, and other cases. And there's also the vertical structure, which is related to the state's positive obligations. And if we look at the right to medical services, the state fails to implement its positive obligation because we don't have mandatory medical insurance. And when it comes to sequestration of the state budget, that's the cutting of public expenditures, then it's understandable that there should be preliminary consultations, and the government should get a special resolution from parliament about the limits of such cuts or sequestration. And the parliament should actually exercise oversight over the government's then expenditure of the sequestered or cut budget. That's what I wanted to tell you when it comes to social rights and legal reasoning in the context of horizontal and vertical structure of the Constitution. Speaking about the limitation to social rights, the principle of proportionality should apply. And should you have any questions, you can ask me. I'll be glad to answer them. Thank you very much for your attention. Thank you, Mikhail, for your presentation, and I will give the floor to Deputy Chair of the State Pension Fund of Ukraine, Ms. Irina Kovalev.
Good morning, dear participants. I would like to thank the organizers to participate in this event and this opportunity for just specialists of the pension fund of Ukraine to hear the presentations of the experts and judges on the issue of implementation of the guarantees of the enforcement of the enforcement legislation. The pension fund of Ukraine, providing pensions at the expense of state funds, is responsible for the correctness of the calculation of the sizes of pensions, for the timeliness of their financing and targeted use of funds. Relations between the state and citizens in the field of state pension provision, in our opinion, are characterized by the following key factors. There are many of them, but because of the shortage times, I would mention only a few of them. The first, complex regulatory regulation, in the condition of which the pension fund of Ukraine are obliged to ensure the correct application of the norms of the pension legislation. And with the availability of the conflict in norms or gaps in the law, the pension fund of Ukraine bears the risks of unjustified assignment of a lifelong pension payment, which can be assessed even as an official crime, as an abusive crime. We must state that in the judicial practice, the factor of justice is increasingly used. The assessment of narrow rights and the adoption of new laws, independence from certain independence of circumstances that determine the size of benefits. Examples are the issues of increase of pensions for war veterans, the procedure for payment of pensions from the state budget to working civil servants, take into account the length of service for periods of unpaid insurance premiums, or because of the absence of supporting documents on special working conditions. When you speak about preferential benefits, also other issues related. At the same time, the assessment of compliance with the requirements of the law of decisions, actions or inactions of the authorities, and the proportionality of these decisions are not always carried out. By the way, it should be mentioned that the binding nature of the Supreme Court's conclusions on the application of the rules of law set out in its rulings, it's a problematic issue for the pension fund of Ukraine bodies, which use it to pay just in a solidarity system. Another factor, financial factor, which implies that expenditures for pension payments may be made only within certain limits, not more, not less, and only for the intended purpose. We should remember always that the timely monthly payment of pensions for more than 11 million recipients is a national task, and it will remain a priority forever. The adoption of decisions by courts that are binding on the increase in the pension benefits from funds that are not allocated from the budgets causes the problem for their implementation. The European Court of Human Rights has repeatedly stated that in determining whether there is a positive commitment to an individual, a fair balance should be taken into account between it should be determined between the interests of the entire society and the interests of a particular individual. In the context of the principles of the funds, but it is not just guarantees the capability of the pension fund to make such payments. The most complicated thing is to enforce the judgments of the national courts related to the recalculation of the pension, and which is done from their body. It relates to the pension as to war veterans, to the pensions of the children of the war, just liquidators of the Chernobyl disaster, which were from to June 13 is carried out by the government relation of 2014, number 440 by the State Treasury Service of Ukraine, according to a separate register. For such payments, the Pension Fund of Ukraine provide relevant certificates of accrued and unpaid amounts. As of August 10, 2020, the bodies of the Pension Fund of Ukraine provided 355,000 certificates. the amount of 1.98 billion, which is 71% of the total amount of that. That's for the payment of pensions accrued for the execution of court decisions after January 1st, 2013, which are paid at the expense of the pension fund of Ukraine, paid by the state pension fund of Ukraine in accordance within the special program introduced by the resolution of the cabinet ministers of 2018, number 649. So in 2018, 2005, payment was made to over 35,000 recipients at the amount of 270 million. Unfortunately, the decision of the Sixth Administrative Court of Appeal dated 2020 declared illegal and invalid items on 1 and 2 of the resolution of the cabinet ministers of Ukraine 649, issue of repayment of arrears of pension benefit by court decision. It has complicated the opportunity of making benefit by court decisions. This has been appealed in cassation procedure. It should be noted that the amount of funds from the budget of the pension fund has not been increased. It should be noted that taking into account the decisions of the Supreme Court in model cases, decisions of the Constitutional Court of Ukraine, as well as judicial revocations of certain resolutions of the Cabinet Ministers of Ukraine on pension provision, the Pension Fund of Ukraine has made the calculation of additional expenditures for pension payments, which may total about 52 billion hryvnias a year. That is, it's 1.5 times than the pension fund pays the money for 1 month to 11 million of pensions. We applied to the Ministry of Social Policy, to the Ministry of Finance, on the need to revise the state budget for 2020. Yet another factor, access to justice. Access to justice. The bodies of the Pension Fund of Ukraine, which are defendants in pension cases, also collect arrears at the same time of mandatory payments and pay significant amounts of court fees. Therefore, we don't have always the financial capacity to pay court fees while appealing court decisions in pension disputes. In addition, given that pension cases are dealt with under the rules of summary proceedings, access to the review of decisions in cassation in order to ensure the same case law in the same type of disputes is virtually impossible. In this regard, in our opinion, the situation will be positively affected by this effective further cooperation with the Supreme Court in the direction of generalization of the case law in resolving pension disputes, ensuring its unity, and taking into account the Supreme Court's legal conclusions in law enforcement and the development of legislative acts to regulate all problematic issues in the field of pension provision. In view of the shortage of time, I would like to thank you for your attention. Thank you, Mrs. Irina. And first of all, I would like to say that with an optimistic note, that we may assume that the number of the funds or the pension fund will be enough to satisfy the needs of the pensioners. It's my great pleasure to give.
It is my great pleasure to give the floor to Ms.
The dean of the
Dean of
Legal University, which is the
Dnipropetrovsk
member, Tatiana, Dean of Law Faculty of the Zaporizhzhia National University, Doctor of Law, Professor, corresponding member of National Academy of Legal Sciences of Ukraine. Our joint work
together
allows
within
me to be certain
Zaporizhzhia
that
State University,
the time
and I'm
schedule
sure
will
that
be
you will
kept. Thank
keep
you.
within the allocated time. Give the floor to Ms. Tatiana Fuley from the National School of Judges. Ms. Tatiana Fuley, the floor is yours.
Thank you. Good morning, ladies and gentlemen, participants of this conference. In my presentation, I will speak about the algorithm of the development of the protection of the complaints that relates to the social payments. Thank you. As we know, The Convention for the Protection of Human Rights and Fundamental Freedoms does not guarantee the right to receive any social security benefits. Article 1 of the first protocol to the Convention, which protects the right to holding of the possession, as European Court of Human Rights repeatedly emphasized, does not provide for the right to acquire property, nor does it impose any restrictions on the freedom of contracting states to decide not to form of any form social security system and choose the type of amount for benefits under such system. However, as such system is established, then the European Court just considering a range of cases, and already the case of Stack and others versus the United Kingdom that just was mentioned, established a certain algorithm of considering cases which relate to social payments, which are subject to Article 1 of First Protocol. For this to happen, the party should have the so-called property interest that are established by two conditions. First, there should be a clear legislation providing for some payment. And second, the person should comply with their legal requirements. In combination, as it has been mentioned by the European Court, then the property interest is established, which is under Article 1 of Protocol 1. And then it will be relevant to have the following algorithm, that if that the person is entitled to receiving social payments provided under the national law, and in such a case, the Article 1 of Protocol 1 does not provide such a right, but the European Court recognized that if the state has introduced a system of social benefits, it must be done in a manner not discriminatory manner. The next slide demonstrates two types of complaints, which are just provided in the context. It might be complaints under Article 1 of the First Protocol to the Convention, and the algorithm for the consideration of this obligation is standard. That is, first, to find out what constitutes property or property interest, then what actions of state bodies constituted interference with the right to peaceful possession of property, and then whether such interference is lawful. That is, whether it is a legitimate, or whether it has a legitimate aid, and whether it is proportionate to the intervention of the public interest into the protection of social interests. Another side of these cases might be under Article 14 of the Convention, combined in conjunction with Article 1 of the Protocol number 1. Then the algorithm is similar, but a bit different, slightly different. First, it is found out the applicability of under Article 1, Protocol 1 is considered. Then its further consideration is carried out according to the algorithm in Article 14. But if the case relates to the provision of Protocol 1, then it is considered to the algorithm inherent in Article 14, which prohibits discrimination. That is, the court establishes what was just non-favorable attitude, who was a model for comparison. That is, what was the difference between the conduct of the person in relation to the comparator, and whether such a different attitude was under the law, and whether it was reasonable in the context of the legitimate objective according to which this difference has taken place. As it is known, as for the first and second types of complaints, the main problematic issue is to specify whether the person has had a property interest. There is still a relevant case, pending case, Sukhanov and others versus Ukraine, and which exemplary nature is that there were 4 periods in this case that were complained against by the plaintiffs. And the European Court just considered whether they was considering just the reasonableness on the increase of the pension according to these 4 periods. This case is widely applied by the administrative courts. The case was that with regards to 1 period, the European Court recognized the presence of the legitimate expectation, lawful expectation, and recognized to be a violation. But as for 3 other periods, it mentioned that the plaintiffs were not entitled to have this expectation for the pension to be increased, and therefore that was not applicable. Thus, a very important issue to understand what are lawful expectations, legitimate expectation. As for Ukraine, there is a range of just judgments on the inapplicability. 3 of them are reflected in the next slide. There's the judgment Vili Court versus Ukraine, judgment that's Fakas versus Ukraine, and Serebransky versus Ukraine, and on benefits to war veterans. The European Court on these cases mentioned that but through that law that reduced these social payments were approved under an regular procedure in a democratically elected parliament, and it was clearly done for economic reasons. That is, the European Court disagreed that applicants' claim constituted a legitimate expectation within the meaning of established practice with regard to that term. And I'll remind that case Sukhanov, Vilchenko, and others versus Ukraine. And in this case, the very fact that the applicants were entitled to certain payments was not challenged by the parties. The question was that whether the property constituted some amount of payments, particular amounts, and the stance of the European Court is quite clear that the amount of these payments and does not constitute a legitimate expectation. Next slide demonstrates a very important case of the European Court, a judgment of the Great Chamber in the case Fabian versus Hungary. It relates to the situation when the person which was entitled to a pension continued to occupy civil service position. It's a good example of both cases. As for the first case, under Article 1 or Protocol 1 to the Convention, whether there was a discrimination. The European Court in both cases recognized the absence of the violations, that there were no violation, mentioning that the applicant didn't fail to prove that while being in the civil service and receiving pension benefits, which totaled more than average minimum wages, and the temporary stoppage of pension benefits was the state's intervention into the respect of his right. and it related to also the individuals who worked in the private service. The administrative cassation court applied this case. Then, in my remarks, there are references to these judgments of the Supreme Court. And the final example, which demonstrates some trends in the development of the case law of the European Court, is the case Belananoid versus Hungary. I would like to mention that the National School of Judges, together with the European Court of Human Rights, organized 2 webinars to analyze these cases. Many judges of the administrative courts participated into these webinars. The main issue, which was tried by the European Court, but there was a legitimate expectation whether the person was entitled to that property. What is just notable about this case, that because of the change in the criteria of the degree of loss of the benefits, that is before that, her ability was 67% after legislative changes in the criteria of the loss of the ability, then 55% when it. As the criteria changed, in addition, the incentive to take into account the criteria that were necessary for receiving the social benefits. That social benefits were abolished for her. It should be noted that in this case, although the European Court recognized it a violation, it was done with the majority of 1 vote. And the opposite opinion seems not less motivated than the judgment itself. This decision is marked as a key case judgment in the HUDOC database. And if we speak about the algorithm it retains the development of the European Court, it's one of the most cited cases relating to the social benefits by the court itself. And I recommend to get acquainted with that, just as also with the joint dissenting opinion of the 7 judges. Thank you for your attention, Ms. Tatiana. We'll correlate what has been said by you. As our organizers say, give the floor to Dmytro Terletsky, the head of the Odessa, just the member of the scientific head of the Department of Constitutional Law, National University of Odessa Law Academy. With your permission, let me just concise is the sister of the talent. Thanks a lot. Good morning. It's my pleasure to welcome organizers, participants of this conference. First, before moving to my presentation, I would like to thank first to all organizers because of whom this event is taking place and for this opportunity to participate in it. It seems to me to underline those important issues that we discuss are discussed by a wide range of specialists and experts abroad, which represent different legal professions. The topic of my presentation is enforcement of decisions of the Constitutional Court of Ukraine on non-constitutionality of some legal acts they are promoting. On the agreement with the organizer, we agreed. I present to you this presentation. So let's move to the next slide. I would like to mention that the position that I will be presenting is of discussion It provides for the engagement of a wider range of specialists to take into account this. I would like to point out that, first and foremost, it should be said, it's rather scholastic, eternal discussion on the legal nature of specially formed bodies of the constitutional jurisdiction, to which the Constitutional Court of Ukraine substantially belongs, which was started, in fact, by the author of this, the Austrian Kelsen. I would like to know that the evolutionary development of the principle of separation of powers, distribution of powers, shows a general trend towards rationalization of the system of state powers in all countries, in Europe in particular, to the rationalization of the system of state power, which occurs both through a clearer delimitation of powers of all branches of governments and would have better quality. And it's very important for me. In the context of the researched issues, the given theoretical statement should be confirmed, among other things, by timely and prompt execution of decisions of the Constitutional Court of Ukraine, which is possible only a result of coordinated and functional interaction of different branches of power, representing legislative, executive, and judicial arms. However, the analysis of legal regulation, I mean legislative regulation, as well as enforcement practice that is carried out in implementing the judgments of the Constitutional Court of Ukraine. Well, it is linked to a range of fundamental problems which have not been resolved yet. Such problems, as I say, are manifested in enforcing the judgments of the Constitutional Court on the guaranteed rights, as an ascertaination or enforcement, which require the positive action on part of the state of taking relevant measures, including legislative, judicial measures, which form the positive obligations of Ukraine on persons under its jurisdiction. I would like to mention that the Constitution of Ukraine, just as you see, they're given the properties of bindingness, finality, and the possibility of appeal, leaves uncertain the procedure and features of their implementation. The judgment of the Constitutional Court in case on the procedure of enforcing resolution, well, it was passed about 20 years ago. Has not this resolved these problems? Having just limited itself to the statement that the act following the proceedings of the Constitutional Court have direct effect and do not require confirmation by any public authorities. And regardless of whether there are such judgments or conclusions of the Constitutional Court of Ukraine on the procedure of the enforcement, relevant legislative acts that have been recognized as constitutional are not subject to appealing, as they have been repealed. Now, what draws attention that actually the Constitutional Court de facto defined the categories of binding and the enforcement, thus defining that all judgments on conclusions of the constitutional are to be self-enforced. At the same time, it is obvious that the implementation of the decisions of the Constitutional Court of Ukraine is not limited to the mandatory requirement of inadmissibility of applying or using some legislative acts or their provisions declared unconstitutional, and evidently requires from other public authorities to take some measures that should be aimed at removing gaps in legal regulation and also to provide for a proper standard. From that point of view, we should mention that the Constitutional Court is a negative lawmaker. And in view of their legal nature, it cannot create new law, despite its very positive influence on the legislature. So please, okay, the next slide. I would like to remind another legal stance that has been expressed by the Constitutional Court in 2016. Actually, it adds the core of the legal positions relating to the enforcement of the acts of the constitutional jurisdiction. This stance is very important. Well, in the context of the protection of social rights, it's the repeated introduction of the legal regulation, which has been recognized by the Constitutional Court of Ukraine as non-constitutional, gives the ground to ascertain about the violation of the constitutional rulings. Nevertheless, one should mention that in cases when the judgments of the Constitutional Court of Ukraine do not resolve the gaps, and in this situation are self-enforced. In this situation, these are eventual exclusions from general rules. Some decisions of the Constitutional Court on the unconstitutionality of some acts just cause the re-establishment or of the cancelled previous acts. And then in this slide, you see the example as a ground to use provisions of Article 22 on the protection of social rights of labor veterans. Nevertheless, only in exclusive cases, take into account that you have up to 1 minute. You don't have any choice for me, then I'll have to move to the statement of these problems, the problems that have not been resolved. In view of my desire to keep to the timetable, I would like to state about 4 main problems to be resolved with the involvement of the one single legislative body of Ukraine. They cannot be resolved by the Constitutional Court or the court. The first, which requires, it's the issue of distinguishing between the mode of entering into force of decisions of the Constitutional Court of Ukraine and the mode of invalidating legal acts that have been recognized non-constitutional. In view of the current procedure for official promulgation and publication of acts of the Constitutional Court of Ukraine, which actually leads to the organization. It is later, that is land under which this act is considered invalid. It's a gap in the procedure of promulgation, official promulgation. I think this should be agreed. That's the first. Please, just I'm as a moderator should reduce you. You have only 1 minute, please. Okay. Then I'll count 3 problems. The next slide. The other important issue to be resolved through the parliament is the issue of the Constitutional Court of Ukraine that the Constitutional Court should specify the terms and the procedure of its decisions, of its judgments to come into force. Third, it's the collision between the provisions of this problem, but particularly this is important for the administration. And the fourth problem, regulation by a special law of the procedure for the compensation of material and material damage caused by a natural or legal person by acts and actions that have been declared constitutional. The application by the courts for such regulations or the provision of the Civil Code of Ukraine, as I see, this problem is not resolved that is, it cannot be resolved without the involvement of the Parliament of Ukraine. And just the final slide. I thank you for your attention. That, well, I was not able to inform about all positions, but I think you will be able to familiarize yourself with it. Thanks you for this opportunity. Thank you.
Thank you very much,
Now,
Dmitro. And we can have Tatiana Kolomois now. Yes, so he had some technical problems, but now they have been addressed. Thank you very much. I'm sorry for these technical problems, and we will try to keep within the time frames. Ladies and gentlemen, I will be speaking about the topic that we in our laboratory are now considering, and we will be speaking about social rights from the point of view of the public servant's integrity and human centricity of law. If the public authorities do not take measures to ensure integrity of its functionalities, then these rights cannot be implemented in practice. So the created rules should make it impossible to distribute public wealth unfairly. So education, public health, and social insurance are the most spread rights, and it's not about the individuals, but it's about the entire system of law. So it's about the distribution of trade, finance, technologies, and we should take into account the factor of globalization, and that the public authorities and other subjects of international law should also be taken on board. So, and we should remember about the application of law, particularly by court. Therefore, it would be logical to speak about modification of rights and the change of acts of legislation in the sphere of social insurance. These productive activities in the context of inefficiency of some acts of the legislation will improve the authority of the courts, and the cumulative positive effect of this activity of courts, in particular in disbalanced economic situation and unfair social distribution, will be conducive to the better binding nature of the application of law. Dear colleagues, I would like to draw your attention to the fact that we've discussed and researched this issue within our laboratory together with Mr. Alexei Makarenkov, and since we have got several minutes, I would like to give the floor to him and he will provide his comments. Thank you very much. I would like to greet all of the organizers and thank for the opportunity to speak at this event. And I would like to underscore that we conducted this research within the project that we implement in our department with support of the Erasmus Mundus program of the European Union. So we formulated the topic of this presentation by bringing together the results, some abstract concepts, and in the field of social protection, which is of very broad scope. And it is next to impossible to take all of the social rights into account. As the previous speakers underscored. So we also invited research consultants. We spoke with the judges of administrative courts, with international experts, so that we could take all the entire variety of opinions in our survey. So, to understand what are the major factors of the reasoning of administrative court judgments. Returning to the topic, I would say that we focused on the integrity of public servants, and they should, all the aspects of this integrity should be taken into account for the positive obligation of the state to ensure social rights protection and promotion could be implemented.
Прохання, що можна стисло до 1 хвилини. Дякую.
Can you please be winding up? Yes. Indeed. This integrity is core, and it ensures the sustainability and consistency of application of law, particularly in the sphere of medical rights and of other social rights, particularly in the context of COVID-19 pandemic. You will know that in Brazil, in 1990s and early 2000s, they tried to overcome the obstacles in addressing certain medical services, and they introduced the procedures of procuring medicines and drugs for the population through private entities, and this experience merits further research and application. Other branches of other branches of power, the judiciary, under the conditions of today, is best positioned to search for optimal solutions in application of social legislation. When response, the state's response should be timely and quick. So any decision that was made by the administrative courts should be honored, and the executive branch should do their best to ensure that those decisions, particularly pertaining to the pension allowances, be enforced properly. Thank you very much. Now I will give the floor to the Justice of the Supreme Court, Mr. Yezerov. And he promised that he will be keeping within his time limits. Thank you very much, dear colleagues, esteemed guests. I will be speaking about the forming of case law in the review of court decisions based on exceptional circumstances. So a review of court decision in administrative cases is provided for in Part 5 of Article 361 of the Code of Administrative Justice. And the grounds for the revision based on exceptional circumstances are the establishment of the Constitutional Court, or by the Constitutional Court of Ukraine, of non-constitutionality of the law another regulation or one of its provisions applicable or not applicable to a certain case. The case law in the making can be demonstrated by cases of revision and payment of pensions calculated on the basis of 5 minimum taxable incomes established by applicable law as of the 1st of January of relevant law according to Article 59 of the law of Ukraine on citizen social protection of Chernobyl accident survivors. Thus, in one of the cases, next slide, please, the court, when satisfying the claim, the first instance court proceeded from the premise that reservists called up as first responders during the Chernobyl accident were military personnel and should be treated in the same way as actively enlisted servicemen. The Administrative Court of Appeal reversed this decision, granting the pension funds appeal. The court reasoned that as the moment of participating in the Chernobyl accident response, the claimant was not on active military duty, he did not meet the eligibility criteria for recalculation of the pension under Article 59 of the law, because his participation in the liquidation of the Chernobyl accident just aftermath was not while he was in the active military duty. And in his cassation appeal, the claimant referred to the Constitutional Court ruling in the case of constitutional complaint by Skripka and Babir, according to which the phrase active conscription or time-bound service was bound non-constitutional. The Supreme Court stated that according to this decision of the Constitutional Court, the phrase active and time-bound conscription service in Article 59 is not applicable because it lost its effect on the date of the Constitutional Court ruling. Next slide, please. So Cassation Court, referring to Article 91 of the law of Ukraine on the Constitutional Court of Ukraine in conjunction with Part 2, Article 152 of the Constitution, stated that the Court of Appeal applied substantive and procedural law correctly, referring to Part 2 of the resolution of the Constitutional Court, which actually deemed the phrase active and time-bound conscription service on the 25th of 2019. The Supreme Court found that the legal relations that arose after that day do not apply to the previous period. Next slide, please. And similarly, the Supreme Court ruled in pilot case, stating that the Constitutional Court of Ukraine changed the provisions of articles, part 3 of Article 59, thus expanding the list of people eligible for this recalculation. So people who participated in Chernobyl response before and were disabled because of that will be eligible for this recalculation, but till 2017. Since Article 59 of the law applied only to those persons who at that moment were on the active time-bound conscription service. And just in this case, the exceptional circumstance was the decision of the Constitutional Court. And the Supreme Court in this very case that you can see on this slide, while rejecting the case, decided that the Constitutional Court did not change the nature of legal relations. And at the time of the emerging of this dispute, the law was in effect and it was applicable. And here you can see that in this very resolution, the Supreme Court noted that the decision established by the Constitutional Court on non-constitutionality of the law can be the ground for the revision of the case based on exceptional circumstances only if the decision has not yet been executed, and that was not the case in this very case. And decision cannot be treated as executed because the case was rejected and the claim was rejected, and it is not enforceable. So in the next case, we see that on the next slide, we see that when court considered this case on the cassation appeal, behaved differently. The court of first instance decided that the established non-constitutionality of the phrase active and time-bound conscription service could be the ground for the revision of the court decision based on exceptional circumstances if the court decision had been enforceable. But since the claim was rejected, the court decision was not enforceable, so it cannot be revised or reviewed. And here we can see the conclusion that the case, the decision cannot be seen unenforceable if the case case was rejected. As a result, the person whose claim was rejected, that is the claimant, is deprived of the right for the review of the judicial decision because of this constitutional court ruling. And if the court decision has not yet been enforced, which means that the decision is not enforceable at all, because at the moment of the application, that court decision was not enforced. Only those court decisions can be revised that are enforceable. Thus, if the claim was satisfied, then the relevant decision can be revised if it hasn't been enforced. If it has been enforced, then it cannot be revised. It cannot be unenforced, and it cannot be applied under exceptional circumstances. So, you can see that the issue like this is sent to the chamber of the Cassation Administrative Court within the Supreme Court for further discussion and resolution. Thank you very much, Mr. Yezerov. And here I would conclude that we've got several questions to the speakers, but given that we've run out of time, we will be very brief. A question from a lawyer of the Kharkiv lawyer. Why courts and judges are reluctant in applying the European social charter? It's a very abstract question, you know. We know that European social charter has been ratified in Ukraine, so it is applicable in this country. But the Supreme Court was first applied it in a pilot case in 2018. And this pilot was about the termination of pension allowances or pension payments to an IDP. Decision in this pilot case was then supported or endorsed by Grand Chamber, and it actually was taken with the application of the European Social Charter. It is being applied, but we cannot say that it is used or applied very actively, nor can I say that judges are reluctant to refer to it. Thank you very much. I hope that this question, this answer will be useful to both the the OSCO and other lawyers. Thank you very much for your attention. We will now break for half an hour. The next session will be moderated by Ms. Kovalenko, and it will start in 10 minutes. Sorry, not 30, but 10 minutes.